5 seconds to go. Start. Notifications orders dated 5th May 2022 and 20th May 2022 have been placed on record by the Election Commission. Respondent number 5. Stop. There is a rejoinder filed by the petitioners dealing with the counter affidavits filed by the Union of India and the Election Commission. Stop. Para. Shri Ravi Shankar, the learned senior counsel appearing for the petitioners has made detailed submissions. Stop. The summary of his submissions is as under: para. That the second proviso to clause 3 of Article 170 of the Constitution lays down that until the figures for the first census taken after the year 2026 have been published, it shall not be necessary to readjust the total number of seats in the Legislative Assembly readjusted on the basis of the 1971 census and the division into territorial constituencies as may be readjusted on the basis of 2001 census. Stop. The exercise undertaken of delimitation / readjustment of the Assembly and parliamentary constituencies of Union Territory of J&K by appointing the Delimitation Commission under the impugned notification dated 6th March 2020 is completely in violation of second proviso to clause 3 of Article 170. Stop. Similarly, the third proviso to Article 82 imposes an embargo on the readjustment of allocation of seats in the House of the People readjusted on the basis of the 1971 census and the division of states into territorial constituencies as may be readjusted on the basis of the 2001 census till the figures of the first census conducted after 2026 are available. Stop. A similar embargo has been imposed by Articles 330 and 332 of the Constitution on reserving the seats for scheduled castes and scheduled tribes till figures of the first census conducted after 2026 are available. Stop. Para. Earlier, the embargo was applicable till figures of the first census taken after the year 2000 were available. Stop. It was modified by the Constitution (start) 84th Amendment Act, 2001 close by substituting the year 2026 for the year 2000. Stop. The government cannot undermine the objects and reasons for the said amendment. Stop. Para. Till the figures of the first census conducted after the year 2026 become available, the number of members of the Legislative Assembly of the states remains the same. Stop. Therefore, the effort to divide the Union Territory of J&K into territorial constituencies was illegal and uncalled for. Stop. Para. Though the petitioners may not have challenged the validity of Section 62 of the J&K Reorganization Act, the same is violative of Clause 3 of Article 170 of the Constitution and therefore, the provisions of Section 62 cannot be implemented. Stop. He submitted that the number of constituencies in legislative assemblies of the state can be readjusted only in accordance with Article 170 and in particular, the second proviso to clause 3 thereof, and therefore, any attempt to make any readjustment of the constituencies of the Union Territory of J&K violates Article 170. Stop. The Constitution of the Legislative Assembly of the Union Territory of J&K must remain the same till the figures of the first census conducted after the year 2026 are made available. Stop.